The Constitution of India protects the right to freedom of trade and commerce. Just like the legislature, this is an important point to understand, just like the legislature cannot take away an individual's freedom of trade, which means legislature cannot make any law wherein it is taking away an individual's freedom of trade as granted to him under the Indian Constitution. Similarly, the individual cannot barter it, that is exchange, cannot barter it through an agreement. So, this is an analogy which can be drawn, that like legislature cannot take away individual's freedom of trade. Similarly, so if you are putting a burden, putting some kind of obligation or a duty on the legislature to protect the individual's freedom of trade, similarly the individual has to take care of the fact that this right, this freedom has been granted to him or her by the Indian Constitution, and by bartering it, it will be at disrespect or it will be going against the Constitution freedom. Again here as well, under like what we studied under agreement and restraint of marriage, agreement and restraint of trade as well, both types of restraint, that is partial or general, are covered. You can see on your screens the last point on this slide is dealing with an example. Let us see what it says. It says there were two rival shopkeepers in a locality. One agreed to pay a sum of money to another if he chooses to close his business in that particular locality. Business is closed, but the proposer refuses to pay the money. So, there was an agreement between the two parties, one made an offer to the other, both were carrying on business or they were running their respective shops in a particular locality, same locality, and one of them makes an offer to the another person that see, you just stop your business, you just shut down your shop, close your business, I will pay you this much amount of money. Basically, he tried to remove the competition which he was having in that particular locality. Yes, now we have Competition Act to take care of these things, anti-competitive practices, but here we are talking about this example in relation to section 27. So, if he is putting that, if they are entering into such kind of an agreement, is it an agreement in restraint of trade and can it be declared to be void? Yes, it is an agreement in restraint of trade. It is void. This provision number section 28 is one of the most important agreement which has been declared to be void under the Indian Constitution. Again here also I would be making a reference to the Indian Constitution, because all the three things, marriage, then trade and legal proceedings, or basically right to go to the court, approach the court in order to claim remedy or relief. This also is a right, a fundamental right which has been granted to us by the Indian Constitution. So, remember in one of our previous sessions we had discussed about Latin maxim, ubi jus ibi remedium, that is where there is a legal right, there is a legal remedy. So, if I have entered into a contract with any person and that person commits a breach, that is he does not fulfill his obligation or his promise under that contract, yes, the Constitution is giving me that right to approach the court, because my right, legal right under that contract has been infringed. I can very well go to the court and put my claim, raise my claim in the court. Now, agreement and restraint of legal proceedings is stating this thing, that if in an agreement made between the two parties, there is say one such clause which says that in case of any future dispute, neither of the parties can approach the court of law, or basically if I may say, they are waiving off their right to approach the court in case of any dispute. Now, say there was an agreement which had this clause that neither of the party will approach the court. Then consider a situation that in future a dispute arose. One of them approaches the court. the other one counters this person's claim of recovery of the money or of specific performance, whatever the case be, he counters that claim. Now, in that case, will it be decided in favor of the person who is going to the court claiming that his right has been infringed, or will the court give the decision in favor of that person who is countering that claim and stating that, see, we had mutually decided that we would not be approaching the court of law, so the court does not have the jurisdiction? The answer is, the court will be deciding in favor of that person who has approached the court and has raised this claim that his right has been infringed, therefore remedy should be granted to him, right. Let's see, let's read now what the provision is stating. It says, every agreement by which any party thereto is restricted absolutely from enforcing his rights, by this we mean that from approaching the court to uphold the rights, under or in respect of any contract by the usual legal proceedings in ordinary tribunals, or which limits the time within which we may thus enforce his rights. So, there are two things again which have been highlighted, that is restricted absolutely from enforcing rights under a contract by usual legal proceedings, that is he cannot absolutely giving away the right to approach the court. This is first. Then it says or which limits the time within which he may thus enforce his rights, which means that, say, again in one of the previous sessions we had discussed about Limitation Act, when we were discussing about consideration, the third exception to our third exception given under section 25. Therein we had discussed about limitation, that is the time period available with the injured party to approach the court to claim relief, which starts from the day the cause of action arose, that is the reason, that is say breach was committed. So, the day from which the breach was committed starts limitation period starts running, and the Limitation Act which is there in existence in India, it highlights or it basically lays down as to what is the limitation period in case of or in respect of different categories of transactions. So, this part says that, say for example, if in a particular transaction or if in a particular sale, say the Limitation Act is giving the time period of say 2 years to approach the court to claim relief. Now, the two parties enter into an agreement and therein they incorporate this period, or they try to modify the period of limitation in this kind of sale, and they write that if any dispute arises in future, then in that case the party can only claim relief if he or she is able to approach the court, say within 1 year of the dispute being arisen, right. So, the law is granting you time period of 2 years, and you in this agreement is reducing that period to half, from 2 to 1. So, again taking you back to the one of the most important essentials which we had discussed, that is, yes, in a contract duties are primarily fixed by parties, but they have to be within the bounds of law, they cannot go against the law. The second clause B states, which extinguishes the rights of any party thereto or discharges any party thereto from any liability under or in respect of any contract on expiry of a specified period, so as to restrict any party from enforcing his rights, is void to the extent. It again simply means this only, that if the written law has given me some kind of right in relation to legal proceedings, in relation to enforcing my right, I cannot, even if through mutual agreement a clause has been incorporated in the agreement wherein this right has been waived off, but it doesn't mean that in future if a dispute will arise, neither of the party can approach the court. As I had given you an example earlier, if the affected party approaches the court will be granting relief. Now, there are exceptions to agreement and restraint of legal proceedings which have been provided under the Indian Contract Act. Let us see what they are. Saving of contract to refer to arbitration dispute that may arise. This section shall not render illegal a contract by which two or more persons agree that any dispute which may arise between them in respect of any subject or class of subjects shall be referred to arbitration, and that only the amount awarded in such arbitration shall be recoverable in respect of the dispute so referred. This provision, this exception basically simply means that, see, I had just given you an example wherein I stated that the parties in the agreement may incorporate that in case of future dispute, neither of the parties will be approaching the court for claiming relief, right. So, that is something which is considered to be void under the Indian Contract Act, but this exception says that in case of commercial transactions, parties can choose the forum. That is, parties may decide, they can incorporate in their agreements that, see, in case a future dispute arises, we will be proceeding for arbitration for settlement of the matter. If that provision is there, then that is not a void agreement, because it is an exception as provided under the Indian Contract Act. The second exception states, saving of contract. Whenever we say saving of contract, as I told you earlier, it means these kind of contracts are saved from the purview of this particular section. Saving of contracts to refer questions that have already arisen. Nor shall this section render illegal any contract in writing by which two or more persons agree to refer to arbitration any question between them which has already arisen. So, the small point of difference between the first exception and the second exception is, in both of them we are referring to arbitration, but in first we are saying that the parties have already incorporated in that agreement that they will be proceeding for arbitration, and exception 2 says the parties can opt for arbitration even at a later stage when the dispute has already arisen. Next is uncertain agreements, or the category of uncertain agreements covered under section 29. Let us see what it says. Agreements, the meaning of which is not certain, which can be seen from the terminology itself, uncertain agreements, which is not certain or capable of being made certain, are void. That means either it is absolutely uncertain, it is vague, ambiguous, and there is no possibility also through which it can be understood what exactly is the term. Let us see, these three illustrations are from section 29 of the Indian Contract Act itself. Let us see and try to understand what is the significance of section 29. A agrees to sell to B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. The agreement is void for uncertainty. This illustration seems to be incomplete, but what it is trying to convey to you is that A agrees to sell to B 100 tons of oil, but A may be a dealer in different types of oil. He may be selling different types of oil. Now, here he is agreeing to sell to B 100 tons of oil. So, I agree to sell to you 100 tons of oil, and I deal in n number of types of oil, but here in this point wherein I am agreeing to sell to you 100 tons of oil, I have not mentioned, I have not made it certain which type of oil I am referring to. Remember, in case of when we were discussing about offer also, so one of the requirements of a valid offer is this also, that the terms should be very clear, offer should be clear, crystal clear, there should not be any ambiguity in it. Similarly, here the agreement, the terms of the agreement should be certain in nature. A agrees to sell to B 100 tons of oil of a specified description. There is no uncertainty here to make the agreement void. So, this second illustration is in contrast to illustration 1. In one it is not made certain, in second it has been made certain. Now A, who is a dealer in coconut oil only, this third illustration is dealing with this part here, that is or capable of being made certain, because in this illustration the terms are such that it is capable of being made certain. Let us see. A, who is a dealer in coconut oil only, agrees to sell to B 100 tons of oil. The nature of A's trade affords an indication of the meaning of the words, and A has entered into a contract for the sale of 100 tons of coconut oil. So here, even if the person says I agree to sell to you 100 tons of oil, it is capable of being made certain, reason being that the person is dealing with only one type of oil, that is coconut oil. Section 30 of the Indian Contract Act deals with wagering agreements, or what we say, an agreement which is in nature of wager. It states, agreements by way of wager void. Agreements by way of wager are void, and no suit shall be brought for recovering anything alleged to be won on any wager or entrusted to any person to abide by the result of any game or other uncertain event on which any wager is made. We have, it's like you are having a bet with a person, right? So it is generally said that in case of agreements which are in nature of betting agreements, there is no, it's like it is only a situation wherein one person is winning something, the other person is losing something. Whereas when we talk about contracts, a general understanding is that contract is a commercial transaction. So any person, any party who is entering into a contract or who is entering into such kind of commercial transaction, in such a case both the parties would be gaining something out of it. One may gain more, the other may gain less, but both are getting something out of it. But the moment we say bet, it is only and only about money, and we know one person will either win the money or may lose it and will have to give that money to other person. So it is not considered to be a valid contract. Exception in favor of certain prizes for horse racing. The section shall not be deemed to render unlawful a subscription or contribution or agreement to subscribe or contribute made or entered into for or towards any plate, prize or sum of money, that is whatever reward will be won as the result of the game, of the value or amount of 500 rupees or upwards, to be awarded to the winner or winners of any horse race. So horse racing, certain prizes for horse racing have been exempted from the purview of section 30. Now the next part says section 294A of the Indian Penal Code is not affected. What do we mean by that? It says nothing in this section shall be deemed to legalize any transaction connected with horse racing to which provisions of section 294A of IPC apply. See the distinction. Here it says certain prizes for horse racing, but here it says there are certain parts, certain aspects related to, a certain transactions related to horse racing which may be declared to be punishable offence under 294A, cannot be enforced under the Indian Contract Act. I would just like to highlight one thing here, that we are talking about section 294A of the Indian Penal Code 1860 here, but now the Indian Penal Code 1860 is no more in existence. So now here we are referring to section 295 of the Bharatiya Nyaya Sanhita. The next is, after wagering agreements, the next agreement which has been declared to be void is agreement to do act which is impossible. So section 56 basically we will be discussing in the next session of ours. Section 56 is basically divided into three parts. So here this part is the first part of section 56, which states agreement to do impossible act. An agreement to do an act impossible in itself is void. So maybe you promise someone that through your magic you will be able to retrieve, or you will be able to find out the lost wallet of someone. So in that case it comes in the category of section 56 part 1, because this is an agreement to do an impossible act, that by magic I'll find out your wallet which you had lost few minutes, few hours, or say few days ago.